So good morning.
Good morning.
We'll talk about people quitting. That's awesome. So who is quitting and why?
Chandler's coming, and he says he has like this incredible news. So when he gets here, I'll act like, you know, okay, never mind, but it's going to be really good.
What's going on? So, it's a typical day at work. I'm putting my numbers, and Big Al calls me to his office and tells me he wants to make me processing supervisor. So, I quit. Why? This was supposed to be a temp job.
Yeah, Chandler, you've been here for 5 years.
If I took this promotion, it would be like admitting that this is what I actually do.
So is it a lot more money?
Doesn't matter. I just don't want to be one of those guys that's in his office until 12 o'clock at night worrying about the weenus.
The weenus?
Weekly estimated net usage systems. It's a processing term.
Oh, that means.
So, what are you going to do? I don't know. That's the thing. I don't know what I want to do. I just know I'm not going to figure it out working there.
Oh, I have something you can do. I have this new massage client, Steve. Anyway, he's opening up a restaurant and he's looking for a head chef. Hi there. Hi. Oh yeah, no, I know, you're a chef. I know, and I thought of you first, but Chandler's the one who needs a job right now, so.
Yeah, I just don't have a lot of chefing experience. Unless it's an all-toast restaurant.
Yeah. Well, what kind of food is he looking for? Well, he wants to do something eclectic, so he's looking for someone who can, you know, create the entire menu. Oh my God! Yeah, I know. So what do you think?
Thanks, Steve. I just don't really see myself in a big white hat.
Okay. Oh, Monica, guess what?
Okay. So millions of workers left their jobs voluntarily, not voluntold to leave. And the question is why? What did they think was going to happen after they left? And what were they leaving for? And we're going to talk about that today. Maybe. So who's leaving? Nation has the highest quit rate beginning in November of 2021, 4 million left in 1 month alone. And then 4 million more left last March. 1 in 5 non-retired US adults say they quit a job in 2021. And for those of you who took the poll, did you see the poll? Do you or anyone you know? I had 25 responses. Only one person didn't know anybody who left their job. So everybody in this room, arguably if you took that, knew someone except for one of you. Adults younger than 30 are far more likely, 37%, so it's a younger crowd leaving, and 24% with lower incomes as opposed to 18% with middle incomes and 11% with upper incomes. And this was across all industries, so, but especially certain industries, which you can kind of guess, hospitality and restaurant industries, trucking and retail. How do we get here? Employees who quit said they did so primarily because of low pay, no opportunities for advancement, and feeling disrespected. So I know we've said people don't quit jobs, they quit bosses and things like that, but I will tell you the #1 exit interview question is, why are you leaving? And a lot of times it was because of more money, better benefits, or flexibility, remote work, or things like that coming out of the COVID. So low pay was the #1 reason, no opportunities for advancement, or feeling disrespected. So other top reasons were feeling disrespected at work, and this includes not valuing healthcare opinions during the COVID pandemic. A lot of employers weren't very flexible and didn't have an understanding of employees or their true concerns. It's easy looking back on it now to say things like, well, it wasn't so bad, but not being flexible with people who were dealing with healthcare issues, who were dealing with childcare issues. It left a lot of people kind of reprioritizing. And when they reprioritized, they said, you know, is this what I really want to do? I've been here like Chandler 5 years. Is this what I want to do for the rest of my life? And now's a great time to jump because people are looking. So the manufacturing workers, it's already a very price-driven, wage-driven, and a lot of times oil, manufacturing, they'll leave for 25 more cents an hour. And so if they're already inclined to do so, as people were willing to offer more money because there were more jobs available, it led to this price and wage war. It also gave people the opportunity to decide, you know, hey, am I really burned out from what I'm doing? Have I had enough of this? Do I want to do something different? Again, like Chandler, do I not want to worry about the weeness anymore? Do I want to go to law school? Do I want to go back to school? Do I want to be a public speaker with videos and charts that don't come up or things like that? So when they leave, what do employers do? I'm a lawyer. There's always a non-compete agreement. There's always an agreement or a lawsuit waiting to happen that keeps me employed. So now we know why people are leaving, but how do you combat that exodus? So one way is enforcement of a non-compete agreement. A non-compete agreement is a legal agreement specifying that an employee must not enter a competition with an employer after the employment period. And so Texas law, we're Texans, and here in the Woodlands especially, we like competition. We like the competitive market. And so these are really disfavored, but they are enforceable if they're ancillary to an otherwise enforceable agreement, and two, contain a reasonable limitation as to time, geographical area, and scope of activity. And that's what I want to focus on today, is that time, geographical area, and scope of activity. So what have the courts said about it, and how has the Great Resignation affected non-compete agreements specifically? So an interesting issue, the accruent case, is a non-compete clause that prohibits employees from competing with an employer anywhere that the employer does business, as opposed to where the employee is located, enforceable. So this is kind of interesting as we get more and more towards remote work. So the employee is applying for a job or here in the Woodlands, and maybe the company that they're going to work for is in Oklahoma. But if their current employer is also in Oklahoma, it may be enforceable. The court held that because the employee had extensive access to the company's confidential information, the non-compete clause was enforceable anywhere that the company conducted business, not just where that employee was located. So an interesting quote from that, it says, accruent seeks to protect its interest in confidential propriety information, technical details about its products, functionalities, and development plans, its sales pipeline, its sales process, its customer preferences, its relationships with customers, and more. Because Short, who's the plaintiff in this, or the employee in this case, was a senior solution engineer, he now has intimate knowledge of all the product functionality. Short knows about unreleased software and a roadmap for future product development. They know about product functionalities requested by customers. They know about business development plans. It knows about market research and its sales goals, its marketing strategy, and a competitor to take business away from accruent in any state or country where accruent does business. It's therefore reasonable for the non-compete provision to extend to every state or country in which they did business. So not just where that employee was located, but anywhere where the company was doing business. And later the court had another, in Fomine versus Barrett, the court comes back and says, however, while you can do it anywhere you're actually located, your intent to be somewhere is not enough. So in this case, the company comes and it says, well, we have big plans. Not only are we in Texas, but we are going to Oklahoma, and we're going to Arkansas, and we're going to Mississippi. We're going to be everywhere. In fact, we're going to be global within 10 years. And so this employee really cannot work globally in 10 years. And the court said, no, a mere intent or a goal to go work somewhere else is not sufficient. You need to actually be located in the area where the non-compete is being sought to be enforced. So here's another. So the D'Onofrio case, and this is a Karen. And Karen works for a vacation company, and she books cruises and tours, and she has a non-compete agreement which says, can an employer prevent an employee with a clause that says you cannot work with a competitor in any capacity, quote, in any capacity. So here she is, she's booking river cruises, she's booking cruises, and she wants to go to another vacation company. And at that place, she's going to do marketing, and she's actually going to be on a different side of it. She's not going to be direct with the customers. And the Vacations Inc. said, no, you can't go work to any competitor. And that is in any capacity, regardless of whether you're booking cruises or not. And the court says such non-competition clause is unenforceable because that's just too broad. You can't keep her from doing anything. And so that came out, and Karen was allowed to go. And this is, I saw you in another mall, Sienna. What about our non-compete agreement? But what about those employees who didn't quit?
So, where do you work? You're
In a tech.
and yeah, what do you do there?
I sit in a cubicle, and I update bank software for the 2000 switch. Well, see, they wrote all this bank software, and to save space, they used 2 digits for the date instead of 4, so like 98 instead of 1998. So I go through these thousands of lines of code, and it doesn't really matter. I don't like my job, and I don't think I'm going to go anymore.
You're just not gonna go?
Yeah.
Don't you get fired?
I don't know. I really don't like it, and I'm not gonna go.
So you're gonna quit?
Nah, not really. I'm just gonna stop going.
When did you decide all of that?
About an hour ago. Yeah.
So you gonna get another job?
I don't think I'd like another job.
What are you thinking about money and bills and?
You know, I've never really liked paying bills.
Well, so what do you want to do?
I want to take Kat to dinner. And then I want to go back to my apartment and watch Kung Fu. You ever watch Kung Fu? Channel 39.
Totally.
You should come over and watch Kung Fu tonight.
Okay.
Great.
Okay. Can we go to lunch first?
Yeah.
Okay. So what is quiet quitting? We talked about it in the first session this morning, but it's a rising trend where employees are doing the bare minimum at work, a reversal of the tendency to go above and beyond in the workplace. Falling rates in 2021 and again in 2022, with now less than 34% of workers surveyed feeling currently engaged in their workplace. So when we look at quiet quitting, this is not new. We've kind of had this catchphrase for it. But retail makes up 20% of the US labor force. And many people enter that retail field knowing that it's temporary and that they're going to do something else. And so it is not a new thing. And so when the attorney, Stephen up there in the first session said, what do you do about quiet quitters? You fire them? I agree. If someone isn't performing, you fire them. But if you have good employees who are just feeling disengaged, what can we do? Because now it's not just your retail sector, but your finance sector. Bloomberg says that quiet quitting is surging and was once the industry with the most engaged workers now feel totally disengaged and disconnected. Sure.
Do you think that it's possibly because more people have moved to letting them work from home and they just are kind of screwing off because they're sitting at their house doing their laundry?
Yeah, I think there's a lot of, so there's a debate. Some people feel absolutely that they are more productive while they're at home. Employees will tell you they're more productive and their managers will tell you they're not, across the board. And so it's really, if you're going to have remote work, it is really important to establish what the expectation is for and to keep those people engaged. And that means not just engaged with work, but also making sure that all of those opportunities that you miss because you're not in the office, that you still have some kind of connection to those employees. And like you said, but if they're screwing off, that's, to me, I'm a lawyer, that's stealing. If I'm paying you to do something and you're not doing it, you're stealing. And I work for the government, so that's even a crime. So how to combat quiet quitting? You communicate with your employees, set reasonable expectations and goals. Give employees recharge opportunities. So these are for people who are in the office. Make sure they're taking time off to force them to get away. I have a manager in one of my clients' offices who I have to tell her that she is not allowed to eat at her desk, because she is one of those people that will keep working and working. She'll work through lunch. And she does that because it's just like that group project in 5th grade. You know what I'm talking about? If she does it, everyone else gets up and they go and they leave and they let all the work fall to her, and she just keeps taking it on and taking it on and taking it on. And so eventually she will burn out. So you have to force people that are good employees to not get into that funk where they're like burned out and not as efficient and as effective as they can be. Another thing is I've had to force employees to take vacations before. I've had to actually schedule their vacations, not because they were going to lose the hours at the end of the year, but because their attitude, you could tell they needed to go. You know what I'm talking about? You need to step away from here. That you are not the person I hired. You need to go. You need to get away. You need a break. And then for the ones that are at home, sometimes you need to say, you need to come back in. You are not the person I hired. You are not engaged. You may, like you said, instead of being at home 2 days a week, you need to be here 4 days a week. So promoting a movement away from the computer throughout the day, avoiding burnout, culture, and activities, showing interest in employee hobbies when appropriate. We talked about wellness plans in the first session, and providing opportunities for engagement, and encouraging service in the community and getting them back involved, even if they're not working in the office, getting them involved in team-like projects if they're interested in that, and you can bring them back. And if not, I'm going to teach you the strongest words in employment law in a minute. My favorite words in employment law. So employment law cases, a lawsuit doesn't occur and resolve in an hour like on TV. Some of the cases which began in 2016 and earlier were decided in 2021, and it will take a while for these COVID cases to make it through the system. So all these questions about remote work and healthcare considerations, quitting because constructive discharge, because I didn't agree with the COVID protocols in my office, those haven't made it through our court system yet, but we can use what was recently decided to see kind of the trends, and we'll talk about the trends in court cases. So there, mask mandates, and just an employee has sued recently and claims she was fired because, here's a remote work one, she was fired because her manager wanted a tour of her home. So she was working from home, and the manager said, well, take me on a tour of your house. And the employee said, no. And so she said, then she said, well, because I didn't do that, the manager totally disengaged with me, and I was ultimately fired. And so we'll see what the court does with that one. What do you think? Any thoughts? Right, the workspace, but not the whole house.
I mean, there's ways of checking if that remote employee has the right, Wi-Fi connections and office,
right.
that they need for their job.
Right, and apparently the manager said, I could see the whole office. I could go anywhere, and where you locate, and this is where you're staying. So why not? And they got in kind of a discussion. Another employee sued because his boss required the camera to stay on him for 9 hours a day. Was not allowed to turn the camera off. So had to leave the camera on. What do you think is going to happen with that one? Unreasonable? Okay. Right, I guess. So we'll see how those cases come out, but in the meantime, the courts were very busy in 2021 with employment matters, especially the Fifth Circuit. So normally the State Bar has the Texas Employment Law Seminar, and they pick a top 10 cases. And every year it's been top 10, top 10. And last year they went to top 15. Well, this past year, top 21 employment law cases. And so we're going to talk about some of my favorites. Some of these are just because I think it's interesting. This one is Watkins. I can't make up hypotheticals that are as interesting as real cases. This is Watkins. And Watkins suffers from anxiety. She is a 17-year African-American dispatch supervisor in the sheriff's office. Another reason I like this is one of my clients, the sheriff's office. And she sued for race discrimination and FMLA retaliation. And the district court threw it out on summary judgment and said, no, let me tell you why Watkins was fired. She was fired for sleeping. And the district court said, if you go to sleep on the job, the sheriff's office can fire you. And the Fifth Circuit actually reversed. And the timing is really important on this because this gives employers something to think about. On January 30th, Watkins' lieutenant sends a letter saying, quote, Watkins, your teamwork was superb. Your effort was great. You actually led to the arrest of people who were challenging to find and to get. And 10 days later, that same lieutenant said, you had poor performance and you are being written up for the following 5 reasons, including sleeping on the job and excessive personal phone calls. And so the next day, Watkins comes in with a doctor's note. And she says, I've told you I have anxiety. This is a real problem. I'm going to need to talk about this. And 2 days after that, the lieutenant requests disciplinary action on those 5 things. Only he doesn't take all 5 things. He takes the one. He says sleeping on the job. And so then the next day, do you see how fast this is happening? The next day, we're talking between January and March. We went from being a stellar, superb person that we put in writing, thank you so much for your teamwork and effort. You are a 17-year employee, to on February 23rd, she says that she's required and needs medical leave, and 3 days later, they fire her. So by March 1st, Watkins is no longer employed. And so the Fifth Circuit looks at the district court and says, yes, I understand what you're saying. Sleeping on the job is probably not okay, but Watkins was able to point to a white employee who had not been fired, and said, you know what, this is different. If you're going to fire everybody who sleeps on the job, that's one thing. But if you're going to counsel the white employee and fire the black employee, that's a problem. Now, what's also interesting to note in this is that she had been caught sleeping before, but the court didn't even address it. So this is Mr. Weber's case. Weber, he works for the railway. He's been there 35 years. And Weber is a train dispatcher, and he has epilepsy. And so whenever he has an epileptic seizure, he's out that day, and then he's also out the next day to recover for lack of sleep and things. And you can almost hear that this company and that the railway is trying to limp this employee along. Have you ever had one of those? They've been there 35 years, and you just can't bring yourself to do something with the employee, and there's a lot of attendance issues, and you're trying to accommodate, and this is no good deed goes unpunished, because he is missing work and he's constantly out. And as we get into the first quarter of the year, they sit him down and they said, we really need you here. You have to come to work. And he says, okay, I will be at work and I will only miss a reasonable amount of time. And by the time he has 35-year employee, he has a ton of time off. And he has accrued this and they're letting him take it. But in the first quarter, right after meeting with him and saying, you have to come to work, he misses 5 times within the first 3 months. And BNSF says, you know what, excessive absenteeism, you're fired. And he sues under the ADA for the failure to accommodate. And the court affirmed, the district court, and the courts were agreed. And they said, listen, we understand what you're saying, but regular worksite attendance is an essential job function. and they're not required to give you time off. You have to at least be at work, within a reasonable amount of time. You can't be out more than you're there. And so Weber says, hey, work site attendance isn't essential. Somebody else can just do it. You should accommodate me. I can be out, and you should just get someone else to fill my shifts. And the court says, no, you have to come to work. That's part of the job description. You have to be at work at least a majority of the time. And this is Lindsley. And TRT is actually Omni, if you've ever been to an Omni hotel. And Sarah Lindsley was 16 years at the Omni Hotel. And she worked her way up. She started as a server, and then she was an hourly supervisor, and then she was a manager, and her boss quits. And so she applies to be the food and beverage director at the Omni Corpus Christi. And when she gets into that job, she realizes that she is being paid less than her boss made, and then the other people who have the other shifts for that same job. And in fact, she's being paid $11,649 less. And in the meantime, she also starts applying for other jobs, especially other ones, internal jobs at the Omni Houston and some other ones. And so she decides, you know what, this is not fair. They should pay me what they paid the men in my position. And so she sues under Title VII, the Labor Code, FMLA, Equal Pay Act, everything. She gets an employment lawyer who throws everything in there. And the district court dismissed her claim, saying that she failed to present that the job was in, quote, any way similar to the higher pay males. Now, the Fifth Circuit looks at that and almost laughs. I mean, they dismissed that almost immediately. They said, that's literally the same job. Like, she took over the food and beverage manager position. It is exactly the same job. To say that that she didn't show that it was in any way similar to another job that the male had is just, that's absurd. So now it shifts to Omni to show a reason, and they kick it back. Court kicks it back and says, you have to describe or articulate a reason for the disparity in pay. And so she also, in the meantime, gets offered the job in Houston. And she says they offer a raise and, come to Houston, be our, I think it's a district kind of oversight of all operations. It's something, whatever is above the food and beverage director. And she's offered it. And she says, no, I quit. I can't possibly work here because you have effectively fired me because this situation with the pay is just too much emotional draining and I'm not being taken seriously. And so I quit. And so that constructive discharge, the court says, yeah, no. If you quit and they offered you a position, the circumstances are not such that a reasonable person would have felt like they had to quit. I mean, one, you have the lawsuit, so you do have a legal remedy for the differential in pay. But two, you've been offered another position in a entirely different location, which is something that you said you wanted, and you got exactly what you wanted for. So no constructive discharge. So what is a constructive discharge? Now employees are quiet quitting are saying, not only did we quit, but you forced me to quit. Constructive discharge. For purposes of discrimination, wrongful discharge, and anti-retaliation and other laws, an employee may be considered to have constructively discharged if working conditions are so intolerable. And in Texas, that is a really high bar. I mean, the cases on constructive discharge are very few and far between where they've been successful. It has to be that the employer knew and actually intended to make the person quit, not just hoped like a lot of employers do. Please go, please go, please go. Right. Yes.
Omni say though, like you're just starting this position, so the starting pay is $11,000 less. He's been here for 5 years.
Right, and they could have said he had more experience. That would have been a great thing. It was dismissed on summary judgment, saying that she hadn't said that the positions are any way similar, and the court said no. Now the burden switches. So now Omni, you have to come in and explain it. So it just didn't. It didn't survive on that. So when someone says I quit, I told you I was going to have some phrases for employers. The really high burden for constructive discharge, right? But if someone says they quit, I accept. Every time, even if you don't want to lose them, when they come in and they say, I quit, I accept. Thank you very much. Let's memorialize this. Put that in writing, okay? So let's be really clear. And then, if that person is someone and you think they're struggling with that decision, or you think, you know what, I would really like to talk to them about why, or how, or can we bring them back on board? Fine. But the leverage switches because they are no longer employed right then. And for unemployment purposes, for basically taking, constructive discharge, all of those things out. If someone quits, you say, I accept. I accept. That's right. So what if they don't quit and you're all of your wishing and hoping and you really need them to go because they have quietly quit, and so now you want to loudly terminate? What do I suggest? These are the 5 greatest words. The decision has been made. The decision has been made. So in the first session, I know Stephen talked a little bit about performance reviews and feedback. I will tell you that I agree with that, but not on an annual basis. You can have a formal annual review, but your employees should never have to wait till January to hear what you think about them. I mean, it ought to be almost immediate. So I'm going to tell you a story. We have a receptionist, and she was not very friendly. I don't know what was wrong, but she just, she didn't have her smile on, and she wasn't very helpful. And I kept getting employees coming by saying, she's not even putting our mail in the right slots. She was dropping calls left and right. She's just not engaged and very unfriendly. Do you know someone like that? They just seem to scowl all the time. And she'd been there a really long time. It's not the receptionist that I thought I knew. And so rather than wait till January to say, hey, you're being unfriendly, you call her in. And I say, hey, the feedback that I've been getting from your coworkers and some people that have been visiting our office is that you're very unfriendly. And she looks at me and she says, I don't know what you mean. And I said, right there, that right there. There is a way to be professional that I don't know what you mean could have been said so much differently, right? You could have said, Amy, that really concerns me. And could you give me an example of how I'm being unfriendly or where you think this is coming from and how can I improve? Or I disagree with that. But that snotty attitude was unacceptable. So my expectation going forward when you leave this office is to put a smile on your face, to be professional, to be kind, to be friendly, and to be helpful. And we don't have to wait till January to have some of those kinds of conversations, right? So what's next at the EEOC? So every year, or every 5 years, the EEOC completes a strategic enforcement plan. And this really guides the Equal Enforcement Commission, or Equal Opportunity Commission's plan for the next, to establish priorities for what they're going to enforce. And so based on recent public session topics, the priorities are expected to include racial and economic justice in the workplace, workers who are vulnerable to discrimination, transgender, immigrant and migrant workers, individuals with limited English proficiencies, and individuals with developmental disabilities. So you can tell that this is happening. Do you remember like 5 years ago, the big thing was sexual harassment and the Me Too movement? And there were a lot of cases filed by the EEOC related to sexual harassment claims and things. And so what we expect is at the end of this year, the EEOC will be putting out new guidelines and a new plan that is going to carry us for the next 5 years, which have these other priorities. And so who here has heard of the Great Regret? Does anyone know what that is? So the Great Regret. So recently, 50% of major CEOs are saying that they are considering layoffs in the next 6 months. 50% of major CEOs are considering layoffs. And what that is, it's making people who are last hired, first fired, and they're looking to jump back. And so I think that what we're looking for from an employment standpoint is very much uncertainty in our workforce of maybe there aren't the jobs out there where people are going to be quitting for no reason. And maybe this great resignation will be a great regret. Any questions? Anybody want to ask me? Thank you.
Okay. Thank you, Amy.